Dartmouth College had undergone something of a crisis of succession when the son of Eliezer Wheelock, his name was John Wheelock, took over the presidency from his father. He decided that he wanted to bring about some changes in the relationship between the president and the faculty as well as the board of trustees. To put it simply, the trustees thought of him as something of an authoritarian, and they removed him from office in 1815. And in order to plead his case to a much larger audience, John Wheelock began to do post pamphlets that he sent to the legislature, and he involved the newly elected Republican governor of New Hampshire, a man by the name of Plumer, to defend his cause. This brought about a critical relationship between the president and the board of trustees, who appointed Francis Brown as the Dartmouth president who would truly succeed Eliezer Wheelock. To put it simply, the state interceded, replaced Francis Brown with John Wheelock, and the battle was on. The state wanted to turn Dartmouth into a public university, with this as the understanding. Any educational institution that had been founded prior to the Revolution and granted a charter by the British monarch would, after the Revolution, in the minds of the state legislators, be understood as a public institution designed in order to improve the public good by educating youth. So they believed that by renaming Dartmouth College Dartmouth University and adding new faculty and a new board of overseers, that they were turning Dartmouth College into a public good that would enhance the commonwealth of learning. Jefferson has an interest because Plumer will write to Jefferson and ask for Jefferson's blessing on what he's done, because the University of Virginia would function as a precedent for what now would be understood to be New Hampshire's preeminent university, comparable in its public affordances to the University of Virginia. Not only were the Board of Trustees all Federalists, Plumer saw to it that most of the judiciary, the state judiciary, which had been Federalists, were replaced by Republican jurists. So Plumer was turning the relationship between Dartmouth and the state into a replay of the partisan crisis between the Federalists and the Republicans, the Jeffersonian Democrats, who understood the war against Great Britain in 1812 to be a decisive moment in demonstrating the United States sovereignty. The Federalists, Webster and Marshall included, more or less supported the secession of the New England states from the Union in the name of preventing the continuation of war and sustaining commerce. John Plumer began as a Federalist. He converted to the Republican Party because he believed that the Federalists had betrayed what he understood to be the primary trust between a political figure and the United States of America. He was a liberal-minded man, and he believed that by translating Dartmouth from a college that was in control, not only of Federalists, but also of Great Awakening-minded evangelists, that he was secularizing Dartmouth, that he was turning Dartmouth into a university that would not be controlled by what he understood to be theological predispositions. He wanted to add science, he wanted to add law, he wanted to add medicine to the college in order to open it up for instruction that would benefit the youth as well as the adults of New Hampshire. The state began to play hardball. They took the charter away from the college. Woodward, who had been secretary and treasurer of the college, moved to Plumer's side. And Plumer and the state legislators decided that they would fine every one of the Dartmouth College trustees who refused to attend board meetings $500 on each occasion they failed. and the college decided to take this to court. They didn't take it to the local police court because Woodward was the chief magistrate in charge of the local police court. So they took it to the New Hampshire Supreme Court. And two Jeremiahs defended the college. Jeremiah Mason, who was understood to be the finest lawyer not only in New Hampshire, but in most of New England, and Jeremiah Smith. Not to be outdone by prophets, the Dartmouth University assigned Isaiah Smith to defend their cause. The case was argued in front of a very, very gifted and erudite and highly informed jurist who was Chief Justice of the New Hampshire Court, his name was Richardson, who wrote a very carefully worded decision that said that John Plumer and the state were absolutely accurate in their understanding of what should happen to a colonial college once the revolution concluded. It should become an instrument for the enhancement of the public good for everyone in the state. That colleges and universities are founded in order to produce a public good called an education that enhances the value of citizenship for everyone who attends. And they refused to acknowledge, Richardson refused to acknowledge this is a violation of Article 1, Section 10 of the Constitution. In order to bring this decision into the United States Supreme Court, Jeremiah Mason, Jeremiah Smith, and Daniel Webster decided to bring the case on the very specific claim that it violated that contract clause of the United States Constitution. And the battle was on a much different forum, a much different arena, and with different players. Webster alone would plead the college's case in Washington, D.C., in front of Chief Justice John Marshall. And this, for Webster, was a dream come true. He's 36 years old. He'd just come from a very, very important career in Congress as a congressman from the state of New Hampshire, and he wanted to develop his reputation as a lawyer who could defend extremely important causes before, in the arena that had become one of the chief educational fora in the United States. When citizens wanted to understand the Constitution, they would go to the arena in which it was argued and thereafter explained in language that would be accessible to every citizen in the United States. And Webster, who was himself a son of Dartmouth, decided that he would also call attention not only to himself, but to the institution that had made his rhetoric, made his oratory, and made his argument truly effective. And so when Webster went to Washington, D.C., he turned it into an occasion in which a case that had brought a very important constitutional question into the public eye, decided he would be the figure who would, through his oratory and his power of argument, enable John Marshall to arrive at a decision that would be important not just for Dartmouth, not just for Daniel Webster, but for the future of higher education in the nation. Webster he matriculated Dartmouth in 1797, and from his first classes, he was recognized as one of the most gifted orators among the undergraduates. He joined an association called the United Fraternity Society. Today's fraternities are given great ancestry by the fraternal organizations of the time that were scholarly and debating organizations. They were debating societies in which students would take what they'd learned in the classroom about rhetoric and argument and logic and turn that into the practical work of working out those arguments in debates with one another. He was the most gifted of the debaters, so gifted that his reputation exceeded Dartmouth, and the town of New Hampshire in the third year asked him to deliver the 4th of July oration. The first public oration that Daniel Webster delivers is in his junior year, 1800. And word spreads that Daniel Webster is a golden-tongued orator. His reputation shifted from the environs of this particular college to the entirety of the town of Hanover, New Hampshire, that designated him as the public orator for a 4th of July celebration in the town. Following his delivery of that oration, he was recognized as a golden-tongued orator who had a great future ahead of him. And he gloried in the response. It wasn't just Dartmouth that he believed was at issue. He believed that a fundamental principle was at issue. The relationship between property and liberty, and the correlation of that relationship with the capacity to establish a contract that would be binding. He believed that the foundation of contract, which was liberty that was grounded in property, had been violated by the state, and he converted the state into the equivalent of the British tyrant, trying to take away from Dartmouth College what the British monarch had taken away from the revolutionaries in the United States. And he redelivered his 4th of July oration before Justice Marshall in defending the college against the horrific measures of a legislature that wanted to deny rights and liberty and property to a great charitable institution, Dartmouth College. There are arguments on both sides, but Justice Marshall, I think, called attention to what he considered the central flaw in Plumer's argument. When Justice Marshall turned it into a question, is every teacher, is every classroom, is every curriculum to be understood as a public good that can be regulated and controlled by a state legislature? By asking the question in that way, he converted Plumer's position into a reductio ad absurdum. No academic can understand his or her work to be under the supervision of the state and believe in academic freedom. When Justice Marshall, in his decision, rephrased Plumer's argument and the argument that informed Justice Richardson's decision with a question: does every academic who delivers a lecture, creates a curriculum, produces an argument, understand the work that he has so created to be understood as under the supervision of a state legislature? Is that the nature of a public good? If so, all of academic freedom has been sacrificed in the name of the public good. When Justice Marshall developed a legal fiction that gave a corporation the status of a person with immortality and the power to articulate the rights and privileges of a person, he created a legal fiction that protected not only private colleges, but the emergent business, the United States. Corporations would be protected against state regulations in the same way that Dartmouth College was protected against the appropriation of the state. And this enabled corporations to proliferate. I think there were fewer than 20 corporations in New Hampshire prior to the case, and there were 900 within 2 years following the case. Webster argues the case and delivers his argument in classic Webster style. He begins conversationally, utilizing the power of logic and connected argument. He then becomes completely absorbed in the principles that inform both the logic and the argument, and his oratory and his passion become one and become united. The intensity of Webster's involvement in what he's saying changes how he's saying it in a way that brings it all to a kind of pitch of passion that allows him to conclude the argument with a peroration that in this particular college has become the only aspect of the argument that most undergraduates now know. It is, sir, as I have said, a small college, but there are those who love it. When Webster delivers that peroration, and he looks directly at Justice Marshall, and he speaks not simply as a lawyer, but as the legatee of an institution that could be destroyed with all of its rights, all of its privileges, all of its collective memory, all of its tradition. He appeals to Justice Marshall as if he is one of the figures responsible for inciting the American Revolution, and asks Justice Marshall for redress against the tyranny of the state legislature. And Justice Marshall, who was himself, as you know, a combatant in the Revolutionary War, is so moved by, let's call it, the resonance of Webster's phrasing, that tears began to fall from his eyes. It was an extremely effective peroration. And everyone in the court, including the friends of the university, wrote back to Dartmouth and said, the case is over. Webster has won the day. His opponent was a man by the name of John Holmes, who was a hack. Webster described what Holmes did as the sheerest nonsense and stuff. And the person that the university had hired in order to accompany Holmes was a man by the name of William Hurt, who was Attorney General of the United States at the time, but had so much work as Attorney General he hadn't prepared the case. So Webster had delivered an argument that was so impassioned, yet so founded on substantial principle, that it seemed for those there irrefutable. However, Justice Marshall saw that the Supreme Court justices were divided in the case. He knew that Story would agree with Marshall, who supported Webster's argument. But he saw that Duvall would not, and Washington would not. So that's why he delayed bringing the decision in the case. He wanted, as present excellent Chief Justices do, to develop this consensus on the case before he pronounced his decision. So he waited 1 year. The case was argued on March 10th, 1818, and the decision was brought in early February of 1819, when Marshall had persuaded everyone except Duvall to concur with his opinion. The university saw that they could not possibly prevail, so they hired an attorney by the name of Pinckney, who was understood to be a lawyer who was at least as gifted as Webster in oratory, and more flamboyant. And he was to argue the university's position with newfound evidence. They'd gone through Wheelock's archive and discovered that Lord Dartmouth had refused to give money to the college because it was not designed to educate Native Americans. And Wheelock had used Lord Dartmouth's money in order to found the college. They believed that this invalidated the contract, and Pinckney was going to argue the same. But Justice Marshall, seeing that Pinckney was there, and knowing that the argument that he would bring to the case had no bearing on the principles that he invoked to deliver his decision, he refused to acknowledge Pinckney. Not because he thought Pinckney had a better, but because Pinckney would only delay the decision. And so instead of acknowledging Pinckney for the re-argument, he began to deliver his decision. And he didn't stop until the entire decision had not only become public, but become official record of the court. Almost all of the students remained loyal to the college, but the university had the buildings, and the university had the keys to the chapel, and it had the charter. But the students believed that the college had truth and principle on its side. So the students went through what could be called the first case of experiential learning. They followed what was happening in the case with scrupulous curiosity. And one of the greatest jurists, one of the greatest lawyers of the 19th century, a man by the name of Rufus Choate, who was of the class of 1819, the class that would be the beneficiary of the decision. He not only followed every aspect of the case, he studied Webster's rhetoric in order to transform Webster's way of arguing into what could be called his internal regimen, the production of his own principle and logic and rhetoric. Rufus Choate became the heir of Daniel Webster, who refounded Dartmouth College by winning that case. And Rufus Choate was the figure who would come to Dartmouth in 1853, the year after Webster's death, and deliver a eulogy that took what Webster's mate in the Supreme Court case had turned into a plaque, Dartmouth College. Joseph Hopkinson, the attorney from Philadelphia who accompanied Webster in the case, came back to Dartmouth in 1819 when cannons were fired across this campus, and the celebration in the town and on this green went on for days. And he said to the then president of Dartmouth, Francis Brown, "You should have inscribed on your walls, Dartmouth College, founded by Eleazar Wheelock, 1769, refounded by its true son, Daniel Webster, 1819.